So, welcome to everybody. I have the pleasure to open this summer school in absence of our dean, who was blocked in the airport somewhere. His flight was cancelled. That's why he was not able to come today. And in order to save time, I will immediately introduce our speaker, Professor Pierluigi Chiassoni from the Tarello Institute of Legal Philosophy, University of Genoa. Tarello Institute is a leading center of legal philosophy in Italy, and Professor Chiassoni is a sort of a leader of the center. So we have traditionally very good links with the Tarello Institute. So thank you very much for accepting our invitation to participate in this summer school. Professor Chiassoni is author of numerous papers and books, mostly in English. His most recent book, as far as I know, that was Interpretation Without Truth. There's no new one, yeah? That is the most recent, is extremely interesting and provoked a very vivid discussion worldwide. So in order to save time, I finished my introduction, and Mr. Chiassoni, the floor is yours. The title of today's lecture is Judicial Discretion and Legal Argumentation.
Thank you very much, Professor Studnicki. It's to me a great pleasure and a great honor to be here, to be invited to open this session of a summer school, the first summer school of a center of interdisciplinary legal theory and constitutional law at the Jagiellonian University. So in a sense, it's for me really a great pleasure. And the title is Judicial Discretion and Legal Argumentation. And since we are in a summer school, let me start with a few methodological remarks. I know that you are both dealing with becoming professional legal theorist or professional constitutional theorist. And it's very important how you are going to do your work. Allow me this sort of notice, because I'm talking for my country, but what I remark when I read essays by constitutional lawyers is that many times they have a poor methodological approach to what they are doing. They, in a sense, don't know what they are doing. They don't have a way, they don't have principles to follow. And this is very important, because the way a constitutional theorist works, his essay can be very important for the legal culture. Think they can affect, for good or for bad, constitutional interpretation. They can affect, when this lawyer becomes a judge of a constitutional court, decisions, the way they argue for their decision. We had in list this also United States examples of this issue. If you read, just a cursory reading, one of the last decisions of the Supreme Court, the decision Dobbs versus Jackson, the one that overruled Roe versus Wade, we can sense that their way of arguing, above all, I must say, those of a minority opinion, is not as sophisticated, as fine as it could be. So these words of mine are to emphasize that the job of a jurist is a serious job, is very important for a society. And so a methodological equipment is necessary. Now, which methodological equipment? Of course, there are many ways of dealing and many principles, many directives concerning the proper way of leading investigations in the field of legal theory or constitutional theory. Now, today I want to focus on a principle which I'm going to call the refinement principle. The refinement principle. The refinement principle I take to be one of a central methodological directive of an analytic approach to jurisprudence, but of course, since jurisprudence is something in constant contact with constitutional theory, civil law theory, etc., has also to do with how a legal culture develops. So the principle of refinement is about this. At any moment in our life of lawyers, jurists, we use a certain terminological and conceptual apparatus to perceive the legal reality, to perceive parts of a phenomena, of a legal phenomena, and to act within it. Is the idea, if you like, of a conceptual scheme, which is like a glass, a pair of glasses through which we look at a certain experience and we act on it through the glasses. Now, the principle of refinement asks to be distrustful of the terminological and conceptual apparatus which at any time we are making use of. When we study constitutional law, legal theory, we learn a certain terminological and conceptual apparatus, for instance, for dealing with interpretation or other subjects. Well, the idea of a refining principle is that this conceptual and terminological apparatus can be always refined, made finer. What does it mean to make it finer? Basically, making refinement involves two operations. First, it involves an operation of widening the terminology, so adding up new terms. And secondly, there's a work of precisification. Each term should be provided with a meaning which should be as precise as possible. Clearly, this is a never-ending job because as soon as new ideas, new perspectives pops up, we have new ways, new resources to refine our conceptual and terminological apparatus. So it's a tantalic effort, but worthwhile the price. So today, I want to show you, trying to show you an example of use of a principle of refinement concerning the phenomenon of judicial discretion and the related phenomenon of legal argumentation, where by legal argumentation, I mean argumentation on matters of law, mainly as performed by judges. So why wasting our time in refining the terminological and conceptual apparatus concerning, to start, judicial discretion? Why? Well, because if we cast a cursory glance on the phenomenon and on the terminological and conceptual apparatus which we run into in the phenomenon of judicial discretion, we find a varied situation. We find, for instance, legislators who in, for instance, criminal codes, I quote from the Italian Criminal Code, 1930 Criminal Code, Article 132, which is entitled Discretionary Power of the Judge in the Application of a Criminal Sanction, Limits. And the article says that within the limits established by the law, the judge applies the criminal sanction in a discretionary way. She ought to provide the reasons that justify the use of such a discretionary power. So if we get close to the phenomenon of judicial discretion, and we find, for instance, these articles. I suppose in the Polish and the Spanish criminal code, there are similar provisions, no, dealing with what we are used to call the criminal sanction judicial discretion, the discretion in determining the amount of, say, jail or fine that somebody has to suffer having been convicted of a certain crime. But if we move from the legislative discourse to the discourses of, you hear me, of legal philosophers, here we find, again, a variety situation. For instance, Herbert Hart, in an essay which he wrote in 1956, but was published only in 2013 in the Harvard Law Review, Discretion, Hart makes an attempt of refinement, we may say. And in his essay, which I think is a masterpiece of analytic methodology, he does three things. First, he tries to define a notion of discretion. And he defines this notion as the authority to choose, given to some person on the understanding that this choice will be performed by using practical wisdom, judgment, prudence, and with the understanding that this person, this authorized person, will provide a justification for the choice authorized, a justification which, according to Hart, will be typically grounded on some principles. Principles which do not dictate one outcome, but only can be used to provide a rational argument for what Hart calls the necessary leap, which the decision maker has to do whenever has to exercise a discretion. There's a leap, there's a jump, I don't know, because the principles do not indicate one way as the only way that should be followed. So this is the general notion of discretion. Then Hart deals with judicial discretion. And he presents as a matter of course that we may single out at least 5 forms of judicial discretion. First, there is the already mentioned discretion in determining the criminal sanction to be attributed to some convicted person. Secondly, which is, I shall call, sanctioning discretion. Secondly, there is a remedial discretion, The discretion judges sometimes have to determine in civil lawsuit which kind of remedy should be provided to some party, like, for instance, injunction or specific performance. Here, Hart is thinking about remedies which, again, are not dictated by the law, but there's a range open to the judge. Third, there is the discretion which judges do exercise when they have to apply norms which includes standards. By standards, Hart is referring to what we in the civil law tradition are more or less used to call general clauses, Ventilbegriffen. This very vague expression like due care, due diligence, correctness, due process of law, etc., which are vague, are indeterminate in a sense. So we may say here a concretizing discretion, because according to our usual terminology, the sort of operation a judge performs whenever she applies a standard or a norm containing a standard is to concretize the standard. This is make specific, make more determinate this broad indeterminate expression. Then there is what we may call interpretive discretion. That is, this is a discretion which, according to Hart, judges do exercise whenever they have to apply a statute, a statutory clause, and the statutory clause appears to be indeterminate in meaning. So there is a disputable issue statutory interpretation that must be solved to settle a case. And finally, Hart speaks of what we may call precedential discretion, which is the discretion which judges have to exercise when they have to apply a precedent, a judicial precedent. But in applying the judicial precedent, some disputable questions arise as to whether this is a precedent or not, and which is the scope of a precedent. Whether this phrase, this sentence in a judicial decision stays or not, is or not the value of a judicial precedent, and which is its scope of application. Does it apply to this case or not? So, and finally, so Hart, you see, develops this analysis, distinguishing different sorts of judicial discretion. All these sorts are cases, situations where the judge is authorized to choose. Is authorized to choose, but has also a duty of justification, because the judge should account for the reasons which are behind the choice she made. And finally, Hart distinguishes between express, explicit, or avowed attribution of discretion and tacit or undercover attribution of discretion. Explicit, according to Hart, explicit attribution of discretion is in the cases of sanctioning discretion, remedial discretion, and concretizing discretion. While, according to Hart, it's are cases of undercover, of tacit conferment of discretion, interpretive discretion, and precedential discretion. So this is a position of Hart. Then I quote two more positions are worthwhile quoting, just to give you an idea. Maybe you already know everything, but let's go into the maze. In a 2012 paper, a colleague of ours from Alicante, Isabel Lifante Vidal, wrote this paper called Poderes Discrecionales, Discretionary Powers. And in this paper, very acute, she says, we shouldn't talk of discretion when problem of interpretation are afoot. There is only, in a sense, she suggests, a case where we can talk properly of judicial discretion, of an exercise of a discretionary power. And this situation is when a judge has to apply what Lifante Vidal calls a purpose norm. A purpose norm. That means a norm which sets a purpose to be reached without establishing the ways to get to the purpose. And the example is, for instance, in family law, when, for instance, we have a certain provision which says that the attribution of parental authority in the case of divorce should be made in such a way to be in the best interest of a child. So this is contains a standard, but from the standpoint of Lifante Vidal's typology of norms, this is a purpose norm. And according to Lifante Vidal, here we can talk properly of a discretion, of judicial discretion as discretionary power and of an exercise of a discretionary power. But then we have to consider one more legal philosopher before concluding this very rapid, very swift journey, which is, of course, Ronald Dworkin. Ronald Dworkin, in a 1963 essay, I consider that judicial discretion. He adopts a, we may say, negationist approach to judicial discretion. He says that talking of judicial discretion is a mistake, is a big mistake. Judges never, at least judges working in our systems of law, in our rule of law systems, never have a real chance to exercise what Dworkin calls genuine discretion. Why is it so? Well, because, says Dworkin, because even in hard cases, that means in cases where there is a rule, but the rule is bad, or there is a rule, but the rule is indeterminate. There is no rule, gaps. There are more rules than necessary, antinomies, or there are rules containing standards, the case of CAR. In all these cases, the judge has to give to the parties the legally right, the legally correct answer to the problem. And the parties are entitled to have a legally correct answer. When there is this situation of uncertainty, that does not mean that there is not, that's Dworkin's position, there is not a legally correct answer. And the judge has the duty to provide it, and since there is a legally correct answer, there is no discretion. So, more or less, this is Dworkin's reason. So, think. We have legislators who talk about this judicial discretion in terms of discretionary powers. There are legal theorists who, following in a sense this idea, conceptualize judicial discretion in terms of power, in terms of authority. Things at heart, the authority to choose conferred implicitly or explicitly to a judge, the authority to choose. Think at Lifante Vidal, poderes discrecionales, though she limits it to a certain point. So we find, according to Hart, there's plenty of situations where judges have discretion, that means have the authority, the power to choose. And these situations include cases of interpretation, precedential discretion. According to Lifante Vidal, the only case where there are discretion is the application of purpose norms. According to Dworkin, there are no cases where a judge has to exercise discretion. So this is a situation of uncertainty, a situation of conceptual uncertainty. I mean, what shall we do? My proposal is that we shouldn't take side. The issue is complex. What we should do is try to refine our conceptual apparatus concerning judicial discretion. We need a wider conceptual apparatus to deal with judicial discretion as a phenomenon. And then, so the point is not saying Dworkin is right, Hart is wrong, or vice versa. This is not interesting. No, I mean, what I think more interesting is this sort of disagreement. Somehow it is interesting for us because reveals a conceptual and terminological inadequacy, in a sense. So we should endow ourselves with a larger net, conceptual net, which be able to capture different phenomena. Because notice, judicial discretion is an institutional phenomenon. So it depends on norms, on the norms that we assume to be binding in a certain legal experience. So from a legal philosophical point of view, it's pointless to say this is the correct notion of discretion, because that can be done only concerning specific legal experience and considering the norm binding in that experience. So, having said this, I think that as a sort of starting point for this refinement job, we may try to make our conceptual apparatus more precise, more fine, by doing this. First, distinguishing two broad, two generic notions of judicial discretion, and then, on the basis of what we have seen, and following one of these of the two, distinguishing several more specific notions of judicial discretion. So I will now, if you have a handout, I tried to send you yesterday, I will deal now with you with two generic notions of judicial discretion, and first time, 7 specific notions of judicial discretion. The specific notions concern specific operation which can be considered as discretionary on the part of the judge. But first of all, let's see which are these two generic notions of judicial discretion, which in a sense should provide the ground for our looking at any judicial discretion phenomenon and seeing, oh, shall I use the notion 1, which I call judicial discretion P, power, or the notion 2, judicial discretion D, which means duty. This is the first distinction I try to define and to subject to your scrutiny, because here it's a collective enterprise or trying to refine our terminology, our concepts, our way of thinking at the legal phenomenon. So let's start with the first notion, first generic notion of judicial discretion, what I call judicial discretion P, power. This is a P because, as we've seen, many, both legislators and authoritative philosophers associate to the phenomenon of judicial discretion the properties of the conferment and exercise of powers or authority. This is the terminology used by Hart, by Lifante Vidal, by, in a sense, the Italian legislator. So, but how can we go to a definition of judicial discretion as power? To do that, I'll make this in 2 steps. The former step will have to do with what I call a discretionary proposition. A discretionary proposition. A discretionary proposition is just a kind of normative propositions. A normative proposition, as we know, I mean, it's in the analytic school, we used to call a normative proposition a proposition of descriptive kind, which is as descriptive meaning, which purport to describe, for instance, that certain norms belong to a certain legal order, that certain norms are efficacious, that certain norms were abrogated, etc., etc. These are normative propositions. Our knowledge of any positive law is made of sets of normative propositions. And so normative proposition can be true or false. Now, a discretionary proposition is a proposition which describes a situation where a judge has discretion. So, for instance, I use this formulation of a discretionary proposition. Inverted commas. In the legal order S, the judge J has discretion in relation to any endoprocessal operation of a class O. In the legal order S, the judge J has discretion in relation to any endoprocessal operation of a type O. So notice when in this proposition I talk of the judge J, I'm referring to judicial offices, judicial organs, say the Supreme Court, the Constitutional Court, civil and criminal judges. These are J. I'm not talking of Mrs. Mary Smith or Mr. John Smith. No, I'm talking of judges of first instance, criminal judges, second instance, appeals, that's it. And notice that the discretion has discretion in relation to any, I call endoprocessual, I don't know if it's correct, I mean any operation which the judge has to perform inside of a trial. And the operation is a certain class, class O. Now, let's us ask for the truth condition of this normative proposition. When is true a proposition like that? In the legal order S, the judge J has discretion in relation to any endoprocessal operation of a class O. When it is true. If we adopt the idea that discretion has to do with power, with authority, we may say that the condition of truth are the following. First, it is true if and only if. First, certain norms, N1 and N, are binding norms in S. First condition of truth. Second, according to the norms N1 and N, as they are presently understood and applied in legal practice, this situation holds. First, the judge J can choose among two or more alternative ways of performing O. If O is interpretation, she can choose among two or more alternative ways of performing an operation of interpretation. Secondly, the choice by J is neither mechanical, that means it does not depend on, say, each alternative as an objective value which can be computed, like you have to give the prize to the competitor who is older. In that case, the choice, in a sense, is you see who's the older one and you give a prize. No, this is a mechanical choice. Neither is a practically necessitated choice. That means, okay, in principle, you could follow path 1 or path 2, but there is only one path which leads clearly to what you have to do. But here we have a situation where the alternatives are all prima facie legally correct. So, at this point, the judge can choose among 2 or more alternative ways of performing O. Second, the choice is discretionary. I don't use, of course, discretionary here because it would be a circularity. It's the choice among alternatives which are neither mechanically ascertainable, not there is one just clearly, evidently correct, but the alternatives are all prima facie legally correct. That means that for each alternative, I can provide argument, reason that can be acceptable either to the legal culture as a whole, or to a certain sector of the legal culture, or to a rational agent, etc., etc. I have to decide. And third, C, the judge can choose. The judge choice is a discretionary choice. I mean, among alternatives, each one of which presents at least prima facie as legally correct. And third, the judge has to provide arguments that show, that say that the choice that the judge has made is, all things considered, the legally correct one. The choice is, all things considered, the legally correct one. So it's this situation. So if these are the truth condition of the discretionary proposition I consider, from this we can formulate the definition of judicial discretion P, power. Judicial discretion P definition is the complex position of power conferred by certain norms of a legal order, S, to a judge, J, in relation to any operation of a certain class, which consists in the combination of 2 distinct subjective positions. First, the permission. Great. First, the permission for the judge J to choose among alternative ways of performing the procedural position. Each one of them presents as prima facie legally correct, the permission. Secondly, the duty of justification. So this first position of this first notion of discretion, notice, we talk of power. Lifante Vidal talks of power. Hart talks of authority. But if we try to disentangle this position, we ask, what sort of power is that? How can we analyze this notion of power? Apparently, the analysis leads us to say that this position of power is nothing else but the combination of a position of permission, the judge is permitted to choose, and a duty of justification, because whatever the judge chooses, she has the duty to present it as the legally correct choice, all things considered. Notice, I stress this point because you remember that when both art, when it talks about authority, thinks that the authority goes along with a duty of justification, an expectation of justification, but and the Italian legislator confers discretionary power, but requires the judge to provide the reasons for that. So there is a duty of justification. So this is the first notion, the power notion, permission plus duty. Now, this notion surely is able to capture many situations which in our legal orders we are used to call judicial discretion. Nonetheless, I think it's not enough. We should not stop to a notion of judicial discretion as power, as I've tried to define it. Why not stopping there? Well, consider interpretive discretion. From the point of view of a judge which is working in a rule of law is one of the themes of this course, this summer school, no? If we think at the position of a judge operating in a rule of law state, in a rule of law legal order, what we find is that the judge, above all, has duties, The judge first has the duty to decide whatever lawsuit is proposed to her decision, which falls within the scope of her competence, the duty to decide. No? Our legal systems are characterized by the prohibition of the denial of justice. One of the signs of modernity in law is precisely the passage from a situation where the judge could refuse to adjudicate, the ancien regime, to the situation where the judge has a duty to decide. And if he doesn't decide, he will be prosecuted for denial of justice. This is what we find in the French Revolution, no? And the idea that Article 4 of the preliminary title to the Civil Code, which is the output of this, no? The judge cannot refuse to judge because there is no law. He has a duty to decide. But secondly, there is a second duty. There is not just the duty to decide in whatever way the judge thinks and likes. The judge has the duty to provide a legally correct decision. We expect separation of powers, connection between legislation and application of law. We expect that the judge provides not whatever decision, but the legally correct decision. So it's the duty to provide a legally correct decision. And third, the judge has the duty to justify her decision, showing that it is the legally correct decision, all things considered. And I mean, this third duty in our constitutional systems is usually to be found in the Constitution. In the Italian Constitution, for instance, there is the duty of providing reason. All judicial enactments ought to be motivated, says the Article 111 of the Italian Constitution. I suppose in the Spanish and the Polish Constitution there are similar provisions. It's a duty, a constitutional duty of justification. So if we look at judicial discretion from this point of view, from the point of view of the fact that judges in the rule of law are above all the addresses of duties, not of powers, of duties. This, in my view, opens the way for introducing a second notion of discretion, which is grounded on the idea of discretionary duties. I can have a duty to perform something, but that something is tightly identified. So I comply with my duty simply by doing what I'm told to do. I have to report to the military office because we are in a bad situation, and so I've been required to go to the military office on a certain date, So I have a non-discretionary duty. But we can have a discretionary duty. I mean, I have the duty, this is my idea in this point, for instance, to provide the legally correct interpretation of a statutory clause, but here the statutory clause can be interpreted in different ways. And so my duty to provide the legally correct interpretation is a discretionary duty because the fulfillment of the duty involves a choice. But my duty is to provide the legally correct interpretation, all things considered. That's my duty as a judge. So if we get into this way of looking at judicial discretion, we can again go back to our normative proposition, the same, but if we look at it from a standpoint of this duty-geared notion of discretion, the conditions of truth are the following. It is true if and only if. Okay, first, the norms N1 and N are binding in S. Secondly, according to N1 and N, as they are presently understood and applied in the legal practice, A, the judge ought to choose among two or more alternative ways of performing O, the one that is legally correct, all things considered. B, the choice by J is neither mechanical nor practically dictated, but is a choice between alternatives, each of which is at least prima facie legally correct. 3, C, the judge has to justify the choice she has made as the only legally correct, all things considered. If we use this condition of truth, then we can provide a second definition, define the second generic notion of judicial discretion. The judicial discretion, the duty. Definition, the complex position of duty conferred by certain norms of a legal order S to a judge J in relation to any end-processal operation of a certain class O, which consists in the combination of two distinct subjective positions. First, the duty for the judge to choose among alternative ways, etc., what is the one which is legally correct, all things considered. Second, the duty for the judge to justify her choice by providing arguments according to which the choice is the legally correct one, all things considered. As I said, I don't claim that this notion, this duty notion of judicial discretion, to be the only notion we should make use of. I think we should introduce it if we want to have at least two notions of judicial discretion, which we can use in connection with empirical situations. Because notice, judicial discretion in both notions depends on binding legal norms. It's a matter of which norms are binding. And so we have any judgment about a judge having discretion or not depends on an empirical investigation, I may say, about which norms are binding and which is their content, how they are in fact applied. This is a job, we may say, for a legal sociologist. But we as jurists, constitutional lawyers, are always necessarily led to do this kind of job if we want to rely on truthful information about our legal system. Of course, there are cases which are uncertain. We are not able to say that there are certain norms according to which the judge is permitted or the judge has the duty to do such and such. So we can, the point is that we should try hard to find the truth condition for our normative proposition. We must do that because otherwise our knowledge of law is mere appearance. So This is the second notion, and this notion, you know, we may also connect it to the former notion in this way. We are used to think that ought implies can, that duty implies permission, in a sense, no? So we may think also of judges by adopting a duty notion of judicial discretion, judges as being permitted to choose, as being in a position of can choose. But this permission, this allowance, this, as Hart calls authority, is to be considered not as an original authority, but as an implied derivative authority. Derives, the permission to choose derives from the duty to choose. It is the permission to choose the all things considered legally correct way of performing a certain operation. This duty implies the permission, but the permission is not originary, is implied. In a sense, this conceptual proposal, notice, wants to somehow suggest that the talk we are used to do about judicial discretion, that it's a power, that judges have powers, etc., etc., this position should be somehow contested. This is maybe is a point for a rule of law perspective. In a rule of law perspective, judicial powers should be are tightly controlled, are derivative from duties. But this is clearly a position which is a normative position, is a way of understanding some basic aspects of our rule of law legal orders. So, for this reason, I won't say that one notion is preferable to the other one. I just lay them down as two tools to deal with our experiences. And of course, we are going to use the one or the other also when we are acting as jurists on the basis, surely, of ideological allegiances, normative choice. But this, I close that. So, at this point, I will stop here and make questions also on the other more specific notions, or I can say something very rapidly about some of them. What?
Maybe the second option is better. How do you think? If you continue now and then we have a general discussion after you finish.
Perfect, great. So now, so far I have provided a generic notion, generic in the sense that they referred to any endoprocessual operation of the class O. Now, which sort of endoprocessual operation could be considered as or are discretionary in the sense I've tried to define? Well, at least, we may single out 7 operations which we may call discretionary, which can be discretionary, where a judge finds in a situation where she ought to choose the best way of performing a certain sort of operation. And these operations are classification, interpretation, concretization, integration, resolution of autonomies, gaps identification, and antinomies identification. Classification. Classification is a very important operation judges performs. Sometimes from classification depends the result of a lawsuit. Consider the case Dobbs versus Jackson. The turning point, at least one of the turning point of the majority opinion is the following. They say that the right to abortion, women's right to abortion, is not a constitutionally protected right, has not the status of a fundamental constitutional protected liberty. This is a piece of classification. They put the right to abortion outside of a set of US constitutionally protected rights. And in so doing, they can say that that's another interesting operation, that there is no antinomy between the Constitution, the federal Constitution, and the Mississippi statute, saying that abortion is prohibited after 15 weeks from conception. Why there is no antinomy? Well, because there is no norm in the Constitution which is in contrast to the statute, the Mississippi statute. So you see, all this operation typically connects. We classify a certain right in a certain way. By this classification, we say that there is no conflict, and so there is no way to annul the Mississippi statute, which is completely within the competence of the state of Mississippi. So classification is an operation which in many cases, like this one, is discretionary, because the judges would have opted for different classification criteria, and so could have reached a different conclusion. In fact, former judges in the Supreme Court of the United States considered the right to abortion a constitutionally protected right. So the matter was, is this right a protected constitutional right or not? And here, so we have a discretion. From the point of view of a duty notion of discretion, there is a duty to choose the alternative, which is, all things considered, the legally correct one, and there is the duty to justify the choice, presented it as, all things considered, the legally correct one. In this case, the constitutionally correct one, because here clearly we can modify, adapt our notion to, for instance, the specific field we are dealing with. No? And now here, if you read the second clause in the definition of classificatory judicial discretion, how, in relation to what a judge can present her decision of the majority opinion as the legally or constitutionally correct one, all things considered. In relation to what? This brings us to the second topic of my conversation, legal argumentation. And we have run into a first form of legal argumentation, classificatory legal argumentation. That means an argumentation that has to do with a classificatory issue. Here we are not interpreting a legal provision or constitutional provision. Here we are, the problem is this right, is this, I call it linguistic entity, because in a sense, a right is a linguistic entity. What it is, American women have a right to abortion. This is, I consider it without any ontological compromise, but let's consider it a linguistic entity. Which is the status of a linguistic entity? Women have a right to abortion in the American legal order, which is the status of this linguistic entity. How do we classify it? Shall we classify it among fundamental constitutional federal rights, or shall we classify outside of this set? And so we leave it to state legislators, state constitutions to decide. It's clear? Now, how this argumentation works? On the basis of what a judge can argue that her classification, its classification, is the all things considered legally correct one. Here, if you notice, I introduce the idea that correctness, argumentative correctness, in all these several sorts of forms of legal argumentation is always relative to what I call a code and to what I call a set of resources. In this case, it is correct, a classificatory argumentation, a classificatory claim. The right to abortion is not a fundamental federal right according to the American Constitution. This classificatory claim, the argument depends on what I propose to call a classificatory code and a set of classificatory resources. What is a classificatory code? This is a little bit mysterious notion. Usually, we are used to think that any form of legal argumentation uses as tools what we are used to call legal arguments. If it is an interpretive argumentation, we use interpretive arguments. If it is a classificatory argumentation, we are using classificatory arguments. But this is surely correct. But I think that focusing only on arguments somehow makes us miss the larger picture we have to take into account. And the larger picture is that arguments are selected to some purpose that the person who argues wants to reach. And the purpose in legal argumentation, we can think of the purpose as established by a rule of purpose in these codes I'm talking about. And consider the case again of Dobbs versus Jackson. The classification by the majority opinion is to the effect that there is no constitutional right to abortion, that the right to abortion is not a constitutional right. The minority opinion claims, contrariwise, that the right to abortion is a constitutionally protected right. So they are using different criteria of classification. But they use this criteria, they have selected this criteria from, we may say, the standpoint of a basic purpose they wanted to reach by classification. Which should be the purpose of my classification of rights as a constitutional judge? Apparently, we have two opposing purposes. The majority pursues a purpose of limiting the classification we are going to make of linguistic entities relevant to American federal constitutional law. This classification should be performed in the pursuit of the goal, the purpose of limiting as much as possible the scope of constitutionally protected rights and widening as much as possible the scope left to democratically elected state legislators. So the purpose in the code, the classificatory code of the majority opinion of the Supreme Court is promoting the most of democratic process decision-making, and so limiting those limits to this democratic process of decision-making. And of course, then you choose certain classification criteria which allows you to say that this right is not a constitutionally protected right. And they use a criterion of classification, which we may call a systematic criterion. There is a rule of a criterion of classification which is a systematic criterion because they somehow develop it out of a system of American constitutional law and constitutional theory. And this criterion is a double test criterion. They say a right which is not expressly enumerated in the Bill of Rights is a fundamental constitutional right if, but only if, two conditions are satisfied. First, this right belongs to the history and tradition of the American people, history and tradition of the American people. Secondly, it is this right essential to our ideal of ordered liberty. So the majority opinion uses a systematic criterion of classification. She could have used an intentionalist criterion of classification, the criterion suggested by the intention of the framers. She could have used a teleological criterion of classification, etc., etc. So here, if you see, we can recover familiar terms, intention, purpose, system, which are terms we use when we deal with legal argument, with legal argumentation, systematic arguments, purposive arguments, intentionalist arguments, etc., etc. Here, apparently, they use a systematic criterion. So we may say that the majority of the Supreme Court presents this classification as, all things considered, constitutionally correct on the basis of a classificatory code, which includes a purpose rule, according to which the proper way of interpreting, of classifying legal entities is a way which favors the process of democratic decision-making, of state democratic decision-making, and limits any limits to this process. So favors, we may say, majoritarian democracy, to tell it in a very rough way. They use this purpose and they select this criterion, a systematic double-bind criterion. For a right to be a constitutionally protected right, it must satisfy both conditions. History being deeply rooted in the history and tradition of the American people, of American states, and be essential to the ordered the ideal of ordered liberty. If we reconstruct the minority opinion, we find a different classificatory code at work. Apparently, they use a code where the purpose norm, the purpose rule is to widen as much use classification, to widen as much as possible the number of rights and liberties which are protected by the federal constitution. And to do so, they are going to use this opinion a little bit, but for instance, it came out in the Teams versus Indiana opinion wrote by Judge Ginsburg, a test which is not double, but simple, simple prong. They say a fundamental right which is not expressly enumerated, a right which is not expressly enumerated is a constitutionally fundamental right if where either is deeply rooted in the history and tradition of the American people, or is essential to order liberty, or both. This notice is very important because clearly, if you talk of a right to abortion, clearly you can say that it is essential to the design of order liberty of the American Constitution, though clearly is not rooted, deeply rooted in the American tradition and history, because the American history and tradition is of laws against abortion. And notice that if the court had used this same criterion for judging the case of interracial marriages in the Lovin versus Virginia decision, the situation would have been that there was no constitutional right to marry somebody of a different race because the tradition of the American states was that it was prohibited. There was a civil war on that. So I'm a little bit simplifying, but what we are interested in is that when we appreciate a piece of argumentation, of legal argumentation, for instance, classificatory legal argumentation, what we have to look for is not just the arguments, but I would say the code. The code pushes us to think that somebody who builds up a legal argument, builds it up on the basis of some purposes she wants to reach. This is captured by the idea of purpose norm. And then you select the classificatory criteria which are more in tune with what you want to reach. Clearly, as you may say, I'm again and again talking about the all things considered legally correct answer, legally correct solution. But of course, there is no objective touchstone to say this is the all things considered and this is not, because the game of legal argument reaches its highest point, I would say, precisely in these codes, in these purpose rules of the codes, which are somehow mirroring the ideology of the law which the judges entertain. And the judges looks at the law and builds up interpretation, integration, etc., the this ideological conviction. My duty is, think the majority, the judges of a majority opinion, my duty is to leave to the states as much freedom of decision as possible. While, according to the minority, my duty as a constitutional judge is to realize the wider possible system of federally protected individual rights. This is the big, this is how it works. The other forms of argumentation I present on the same way. I mean, we can talk of an interpretive discretion, which refers in the argumentation has to do with an interpretive code. Then we have situation, operation of gaps integration. There's a gap. How should we go to fill it up? Again, a judge is going to use an integration code where there is a purpose norm which selects certain integration or addition rules to add some new norm to a previously identified gappy set, etc., etc. I will stop here because I think and if you have questions also to other parts, I'm here to hear your questions and queries. Thank you.
Chiassoni, thank you very much. Your lecture was extremely interesting and very clear what is important here. So thank you very much. So we have more than half an hour Q&A and comments.
Of course, questions also to the parts I didn't cover. That means if you have curiosities about, for instance, gaps identification or antinomies identification argument, please go ahead. I want to stress this because usually identification of gaps, identification of antinomies goes somehow overlooked in our reconstruction and theories of legal reasoning. We usually focus on interpretation. Clearly, identification of gaps and identification of antinomies is most of the time parasitic to operation of actual interpretation. According to the way I interpret constitutional clauses, statutory clauses, there is not an antinomy, there is not a gap. But not only, we've seen that they depend also on, for instance, classificatory issue. Thank you very much.
Professor Morazo.
Thank you very much. I have two very generic questions in the background of your presentation. The first is the relation, in your opinion, between duties and powers, because it's part of your presentation, and then this idea of judicial discretion, power, judicial discretion, duty. I don't know, but in my, I guess that in fact, always that something has a duty to make an institutional action, she needs a power, because if not, it's not possible to do that. For instance, I have the duty to do not park my car in this street, for instance. Well, this is not an institutional action because it's possible to park cars without rules. It's possible in this sense there is no an institutional action. But if the police officer has the power to put a fine if I park in a forbidden place, in a prohibited place, then for the effective capacity of the officer to put a fine, to me, is necessary that the police has the power.
Yes, it has the power.
And I think this is the question. It's obvious that the duty of the judges to decide, and the prohibition of liquid and so on, presupposes the power, because deciding legal cases, it's an institutional action.
Mm-hmm.
That's and in this sense, in this kind of questions, in my view, power and duty are intertwined.
Mm-hmm. Mm-hmm.
That's my position. The second, even very generic. The second is your idea of discretionary duty. In some sense, I think, Pierluigi, all the duties to do generic actions, in fact, all the duties are in this sense discretionary, because we could think about a very ordinary and typical duty. The sergeant orders to the soldier to washing the dishes. This is washing the dishes, right? Very concrete order, very concrete. But the soldier, it's possible that the soldier can do his duty or her duty, can do in an infinite spectrum of ways of doing the action. Why? It's possible to wash before the small dishes or the big dishes, or more slowly or not, or more water, less water, and this is important, even in an efficient ways, even in the ways that we consider a deficient, the moment I said deficient way to do that. For instance, using a toxic detergent that affects to the dishes and the future produces bad results in other soldiers. Well, in this sense, it's not different in the judge. The judge has a discretionary duty in the sense that it's possible to do to accomplish to comply her duties in different ways, in several ways. That's normal because it's a duty, and all the generic duties are in this way. And in this sense, I think was necessary would be necessary to put more clearly in which sense this duty is more discretionary than all the duties are discretionary. That's okay.
Yeah.
So,
Thank you.
Thank you very much, Jose Juan. The first, both very interesting. Let me say that you mentioned that the exercise of fulfillment of duty, first point, of a duty by judges presupposes a power. Yeah, but indeed, this is a different power. Judges are given the power to enact decisions which are binding to the parties until they are not destroyed, when they say, by a superior decision. No, but this can combine with so they have the power to impose a decision. Which decision they have the power to impose? They have the power to impose a decision, okay, that from the point of view of the norms should be the legally correct one. Of course, the decision stands even though it's not legally correct. And that's why we have a second degree or a third degree review, no? But that's, I would say, I think, so it's not the power which is presupposed, is not part of a notion of judicial discretion I try to reconstruct, because it's independent of judicial discretion. You have the power to decide, to make decisions which are binding for the parties. So I can go to the official with a decision and take your money because I won the lawsuit. No, this is independent of. So I think when sometimes we talk of discretionary powers of a judge, in fact, we make reference to this power, but it is the institutional power of making binding decisions. And which other norms go along with the norms which give this power? I claim that in a rule of law state, possible reconstruction, the judge has these duties, has the duty to decide. So not only the power, but the duty to decide. Has the duty to decide in a way which is legally correct, and has the duty to justify, presenting it as the only legally correct. So from this point of view, the power which is relevant to my purpose, to the purpose of the reconstruction of the notion of judicial discretion, is not the presupposed power, institutional power of making binding decision, but is the permission, implied by the duty, as you said, by using your second case. No, I mean, we have a duty, the judge has a duty to decide in a legally correct way. This duty implies the permission to make the choice, but it's an implied permission. So that's how, thank you very much for that, because the second point, you are right, though I would say that also the duty to wash the dishes by 12 o'clock. Right, I can do in a several alternative way. I can use a poisoning, washing, all the but the point, I think, this is very easy what you said, because maybe the distinction between a discretionary duty and a non-discretionary duty, to make precise, thanks to your remark, what I said above, is this. A non-discretionary duty, its fulfillment consists in a state of affair which is empirically verifiable. By noon, I enter the kitchen and I see whether the dishes are washed or not. While when we have what I've called a discretionary duty of interpretation, I have no kitchen where I can enter and say, this is not the legally correct interpretation of things, because here we have no empirical reality which can help us on that. Again, report to the military office at noon on April 12th. Either I do a report or I don't report. Okay, there can be some evidence problem, but this is an empirical verification if I have fulfilled or not the duty. While there are duties which maybe we could change to this. There are duties the fulfillment of which is subject to empirical verification. Let's call it a non-discretionary duty. And there are duties the fulfillment of which is not open to empirical verification. Because how can we verify what is the legally correct interpretation, all things considered? So, thanks a lot. Thanks a lot. This is it.
Yeah, Pierluigi, that was very interesting indeed. I have a couple of questions. If there are no people asking or willing to ask questions, I'll take some time to.
Okay, not too much.
Okay, okay. Maybe these are simple questions that can be asked and replied to easily. So the first question is about refinement principle. You mentioned this is a very general question. So you said that this principle requires widening and precision with regards to the ways of our legal thinking about certain kinds of legal phenomena. So this is obviously a pragmatic principle, a kind of ameliorative, I would say, ameliorative. So it contributes to the betterment of our thinking and, in result, a betterment of our institutions, probably, our legal reality. My question is, because I remember realists like Holmes or, for example, Frank or Pound writing about legal fictions, or writing about false interpretations, or, for example, these remnants that we have to think about, and maybe we should get rid of them. So, is refinement of your principle able to exclude something from legal reality in the end, like withdraw certain ideas, or it is only kind of refinement that is conservative in a way, that it tries to save as much phenomena as we have in our legal reality. So my idea is that probably Holmes would not agree about refining. He would say we should get rid of things that does not work. Whereas you're trying to save as much phenomena as you can by saying, let's refine it, let's widen the ways, be more inclusive, right? So this is the first question. Shall I ask the second?
Ask the second.
Okay, so the second is about what you said about disagreement as a reason for refinement. You gave this example of discretion dispute between Dworkin and Hart, for example, and a couple of others. So the idea is that the fact they're disagreeing is a reason for refining the views. The ironical consequence here is that when you try to be inclusive and refine the views by introducing novel distinctions and trying to put their views together, you end with an inclusive view with which none of them would agree. So actually you're achieving something. You might say you're doing something better, but you can't, I'm not sure if you would get into discussion with them at some point. Because actually the point is that when you say that you can refine their views and you don't want to, and this is what follows from my earlier question or my earlier worry, that you want to be conservative and safe as much as you want, then you just simply argue or accept the fact that they're all right to some extent in what they're saying, right? So you take them to be a kind of peers who are right, and yeah. So that's the second worry.
Thanks.
Many other worries, but I don't want to.
So please.
Okay.
Yeah.
Thanks a lot. Surely, how does it work, the refinement principle? It depends which is the terminological and conceptual apparatus we apply this principle. So it can have an effect of purifying the terminological conceptual apparatus of bad ways of thinking, of the use of words which were objectivized. Think of Kelsen's, for instance, struggle against fictions, against the fiction of sovereignty of a state. So I would say it can be conservative or reformatory according to the terminological conceptual apparatus which is being considered. You are right when you say there is I would say an enlightenment presupposition. The idea is clear thinking, get rid of ideological rubbish, in a sense that if something is ideological, it should be disclosed as an ideological piece of thinking. And so done because we have some ideological purpose to achieve. But so can be, I would say, it is not necessarily conservative. Bettering clearly implies a change. So we present in a better way certain phenomena when we are after trying to understand the phenomena, but can also be that we are reformatory because in this betterment we get rid of ways of talking, of terms or concepts which are run against a clear appreciation of a phenomenon. So I would say it depends. It depends how we apply which is the subject. Can be very reformatory in sense, surely. And how does this reconstruction cope with a debate? I would say that both Dworkin and Hart, in a sense, they are somehow trespassing outside of the field of legal theory, because by mentioning authority or by mentioning duties, as a case of Dworkin, clearly they should have made clear that this notion can only be applied in connection to a certain a given legal reality, no? You can establish as a legal theorist that judges have the authority to interpret. This is a piece, I would say, of legal dogmatics. I'm not saying it is something bad. I say that it is a piece of legal dogmatics, has to do with interpreting, reconstructing the duties and the powers of judges. So if you want to keep in the level of legal, general legal theory, legal analytic, legal philosophy, you should, okay, you can define notions, but you should always formulate a sort of a cautionary note. I'm not saying this is the only notion we are going to. The notion can be used if a reality stands on it. No, so I don't know if I have an answer to your query, but.
Other questions? If there are no questions for a moment, I would like to come back to the first question of Professor Morezo relating to the problem of power and duty. That's a problem I'm struggling with for almost 50 years. I still do not have any clear picture. And my question is as follows. Let us assume that someone has a power. And then I think that there's quite a different thing to have a power, and quite a different question how the exercise of the power is regulated. I think there are three scenarios possible. In most cases, if I have a power, I have also a duty to exercise the power. If I have a judge, I have a duty to exercise my power and to issue decisions. It might be so that I'm only permitted to use the power. If I'm a policeman, so well, I see that somebody is crossing the street in irregular way. I have I'm permitted to punish him, but I don't have a duty to punish him. But also, and that is probably the very rare case, the use of the power may be prohibited. So that would mean that then my decision to use the power would be valid, would have all legal consequences, but I may be punished for using this power. Mm-hmm. So that would mean that power on the one hand and duties, permission and so on belong to different worlds. That means that there's different types of deonting modalities, so to say. Do you agree with that?
I agree with it. It's really a maze. And I think that, it's really a maze. And I think that the chief responsible for the maze is the word power. The word power should be somehow, I think, always refers to a complex set of subjective positions, which includes some permissions. For instance, the power of judges to enact binding decisions, no? The judge is permitted to enact a decisions. The parties and the officials have the duty to enforce the decision if the parties do not abide by themselves. The parties have the duty to abide by the decision or appeal against the decision. This stems from a set of norms, no? I think that power is just usually the combination of permission plus duties. And
so that would mean that power is reducible to...
Yeah, I'm inclined to think that.
Yeah, well, I may not have convincing arguments, but I'm still not convinced. You know,
there is, in fact, I think power is a fiction word in a sense, very, very suggestive. But if we try to, crack it, we get. Of course, we have to take into account the normative set, which is the normative background against which we claim that somebody has the power to do something. No? Without a careful analysis of these norms, we're not able to disentangle how do they work? So where does the permission comes from? Where does the duty come from? How do they relate? And sometimes we say that you are permitted to adopt certain decision with certain properties, and you are prohibited to adopt decision with different properties. No, Professor, it's really a very complex issue, and I think it is paradoxical in a sense that such a basic notion, apparently a basic notion, as power is still waiting for a convincing analysis, which make us get rid.
A lot of young people.
No, because power is a word with a powerful emotional meaning. Powerful. Permission looks modest stuff, but power is different. And so we like sometimes talking with noble words and not use words which appear less noble. But this is just a sort of psychology of jurisprudence.
Any other questions? If there are no other questions of Professor Chiassoni, thank you very much for a very interesting lecture, and we hope that's not your last busy question. That's the question. Yeah. Oh, sorry.
So, Professor, thank you very much for your lecture, and I think very simple question, because to these three central issues, central terms of this lecture: duty, permission, power. I need to put some emphasis on a third, I think, valid term, the term of responsibility, because I have some paradox in my mind. Because in one hand, duty is some kind of pointless without responsibility, with some moral, legal, cultural responsibility. And on the other hand, our imagination of discretion is connected with lack of responsibility. In this space of discretion, one decision or another, there cannot be very strong legal binding of judges, because there's a sense of discretion. But on the other hand, we don't want judges to have a decision, to write something on the paper, make some decision, some justification, no matter what. We need to get them to have good decision, some well-justified decision. And how to deal with this problem of responsibility? Because on the one hand, the sense of discretion is some lack of responsibility, but on the other hand, if you want judges to have serious decision, carefully make decision, there has to be some responsibility for making bad decision, less carefully decision. So how to deal with this problem?
First of all, I would ask you, what do you mean by responsibility? Because this is clearly, what does it mean that judges have responsibility for properly argued decision? Suppose this is our normative proposition. And which are the truth conditions of this? When it is true, what would you say?
I'm not sure, because it is a question. Because the sense of responsibility, there can be many senses of responsibility: moral sense of responsibility, legal, cultural.
Okay.
It's not only this legal sense of responsibility, like criminal responsibility and so on. Maybe not this type. But we have to put some emphasis on the responsibility of the judge if we want discretion to be a good tool to make social peace.
But it's very interesting. But you think the problem is that if we don't get a clear idea of what we mean by, say, let's take a different proposition. According to moral system, to critical moral system, M, judges have responsibility to argue properly their decision. What does it mean? What makes this true or false? I would say that you are going to look at the norms or principles or standards which make up critical morality M. And what are you going to find there? I think you're going to find norms which impose what we could call a duty of proper justification. They define what is a proper morally justification, and they may also point out the consequences of violating the duty, like the judges who does not properly justify his decision from a point of view of critical morality and should be banned from the tennis club for 10 years. Something like that. So I'm joking, but I think the first thing when we ask momentous questions like this is to disentangle the meaning of the key terms. That helps us, and the tool, another tool to be used, the tool of a normative proposition and asking what makes it true or false, which in a sense, with my friend, is a Benthamite idea, no? The contextualization, which is really the basic of any fight against fictions, fictitious entities, all this. So contextualization, put the word in the context of a sentence, and think, what is the meaning of this sentence? What makes it true or false? That's really, I think, the recipe, part of the recipe to clear thinking, to disentangle apparently unmanageable problems we have in law and morality.
Any other questions? Oh, yes, please.
Okay, so I would like to ask a question about this typology with judicial discretion power and judicial discretion duty. I've been wondering, how do you classify concept of, because there's sometimes judicial courts have to resolve conflicts of competences between certain institutions or certain state bodies, and how would you classify those resolution of conflict of competences to discretion of power or discretion of duty? Because I have a problem, because I'm wondering, for me, it might be judicial discretion of power because both ways might be of resolving this conflict might be at least prima facie correct, but in some way it resembles to me judicial discretion duty, but in the type of integration of gaps. Because if there's a conflict of competences, there have to be maybe some gaps in the law before, and this had to be integrated.
Thanks a lot. I would say first that we can't settle the issue outside of a certain legal order. So we should take into account these two notions of discretion, generic notion of discretion, and then go in and see the norms, what they say, in a sense, but not from a point of view of a legal sociologist, not of one who interprets the norms, but of one who just detects as the way they are in fact understood and applied in a certain moment. This is the first thing. Secondly, if we look at the problem which you have mentioned from the point of view of several specific notions of discretion, probably, as you said, the operation of settling a conflict of competence involves several discretionary operations, because again, we should see if there is a gap. So first we should decide whether identifying or not a gap. Secondly, if we have identified a gap, we have decided that there is a gap, we have to fill it up. And so we have to use integration discretion to fill up the gap. Then there may be an antinomy, may raise an antinomy. So again, so some problems involve many operations which we may consider discretionary in the sense that involve choices among alternatives which are all prima facie legally correct, but we may assume, according to the position we adopt, that there is a duty in any case to choose the all things considered legal solution to the time. I don't know if I have answered to your doubt. Let's say, I would say it's important that you look at the provisions which, for instance, I suppose in the Polish constitution concern the competence of the constitutional court, no? And so here, of course, you can provide your own interpretation, but also from your point of view, first is interesting how these are interpreted and what are the opinion about the interpretation. So you may also come to the outcome that there is a debate, that the issue is not settled. Somebody claims that that provision ascribe that competence, give the permission, other a different permission, other in terms of duty. Well, but you can get out of that without considering seriously the content of a specific legal order, I think.
Any other questions? I don't see any, so again, Professor Chiassoni, thank you very much for your lecture.
Grazie a voi.
Thank you very much for your questions. Great patience in it.